Thank you everybody for joining us today. Joel Silverman here at Silverman Law Office. Thank you for coming on today with the third episode in our estate planning webinar. Today we're talking about how do our assets transfer to either the next generation or to the people we want it to go to. So I've come up with a little acronym here. It's the W.T.O. No, we're not talking about the World Trade Organization. We're talking about wills, trusts, and other. That's the ways our assets can transfer around. So we're going to start out with the W, the will. If you'd listened to episode 2, and I'm not going to believe that you did, because if I did, I'd skip a big step, which is what's a will. So we'll just repeat it real quick. A will is a written document that directs somebody, your personal representative or your executor, to go to the court and get the court to approve the will, to give them the power to go transfer your assets the way you want. Pretty simple, that's a will. What's a trust, you say? Well, geez, trust is just like a will, except for it's more like a contract between you and yourself, and it tells whoever the trustee is where you want your assets to go. Whether you're incapacitated or you pass away, it directs how those assets are supposed to be handled. So we've got the W for the will, the T for the trust. What's the O? The O's the big one. Now, first of all, if you don't have a will, you don't have a trust, what happens? You get the state involved. And who wants the state running all of their assets and not giving direction to how you want things to be handled? So if you do nothing, I just can't tell you how much that you've made a lawyer's dream, because the lawyers get involved and the fights happen, and we all know that story of who makes out like a bandit. The lawyers do. Also, who makes out like a bandit? The state. Because the state dictates by state statute how your assets get transferred. So please get in, get that will, get that trust, whatever it is, by the direction of your attorney, get that in, get that set with your estate planning attorney. Now you say, Joel, you didn't mention the other. Well, I mentioned the first part of the other, which is the state. Nobody wants the state coming in. However, there's other ways to transfer our assets too. Financial accounts. Joel, how are my financial accounts handled? Well, it's pretty simple. Financial accounts have what we call a beneficiary designation. They're either called a payable on death, which is a POD, or a transfer on death, which is TOD. And so what that says is, if something happens to me, I've filled out that payable on death or transfer on death beneficiary designation, and the beneficiary designation says, here's who gets that financial account. The will does not control it, only that account. We see this happen a lot where a couple gets divorced. The spouses after divorce don't fix their accounts. They might do a new will, but the account doesn't get fixed and they pass away, and then there's the ex-spouse who survives them gets the financial accounts. And that's not who they wanted to get it. They might have wanted their kids or their new spouse or somebody else to get that financial account, or life insurance falls in there as well. Life insurance always has a beneficiary designation, but that beneficiary designation controls. Real simple. Doesn't matter what your trust says, what your will says, none of that matters. The state doesn't matter. That beneficiary designation controls. Okay, so that's the first one in the other category. What's another one? You say, Joel, come on, there's got to be others. And I say, you're right, because there are. Well, what's another one? Another one would be what we call a joint tenancy. Where do we see joint tenancies? Joint tenancies come up in real estate more often than anywhere else, but they also come up in financial accounts at times too. So a joint tenancy is where two people own the piece of property and they own it undivided. So whoever the survivor is the person who will get that property. You'll oftentimes see it. Joint tenants with rights of survivorship, JTROS, is sometimes what you'll see. That's all that means, joint tenant with right of survivorship. So when you see joint tenancy, that means the survivor gets it 100%, no strings, no questions asked, that's who gets it. And there's nothing your will can do about it, nothing a trust can do about it. The joint tenancy is the survivor of it. So you always want to make sure those accounts, those documents are done right. Very important when you're doing your estate planning. The last one that we also get in real estate, which is new for most states, Montana's now had it, I believe, 6 years, is the beneficiary deed for real estate. Beneficiary deeds are really important, folks. This is a great way for us as planners to use a tool that allows us to transfer real estate to the next generation or to any of the survivors we want without having to go through probate. If we can avoid probate, the better, because that's where a lot of the cost is. We want to avoid probate as much as possible. And so with a beneficiary deed, when you pass away, your children go record the deed or record your death certificate, and that allows the clerk and recorder's office to transfer that real estate to the survivors listed on that beneficiary deed. No different than a beneficiary on a financial account, but it's a special recorded document. We incorporate that into our planning with a majority of our clients. You usually don't need a beneficiary deed if you have a trust, because the trust is going to be the holder of your real estate, and the trust will control your real estate, your financial accounts, everything, if a trust is done right. If you have a trust and your trust doesn't list all your assets in it, and you don't have the documents, the deeds or any of the documents securing all those assets into the name of the trust, then please give us a call, because that needs to be fixed. We see that a lot. This happened a lot in the 70s, the 80s, 90s, even early 2000s. There were insurance people traveling around Montana telling everybody what great, wonderful things these trusts were. They'd sit down with them. They'd write up the trust right there from a form on their computer, and they'd spit them out, or they'd send them to them after they'd get them typed up. But what they'd miss is transferring the assets into the trust. If you miss that transfer into a trust, now you're back to dealing with either your will or the state to see who's going to own your assets after you pass away. Or even worse, if you become incapacitated and now you have people clamoring to try and become your guardian through the court so they can control your assets, and that can get ugly. Please, please, please give us a call today. When you call our office, and if you mention watching this webinar, we're going to give you a special deal. Mention the webinar to my team, and they're going to set up an appointment for you. First and foremost, it's a 1-hour consult. Number two, we're going to give it to you for free. That's a $300 value. We normally charge $300 for that consult for 1 hour of time. And then what we're also going to do, we're going to send you this book. This is our new estate planning book. It goes through a lot of the problems that we've talked about in our prior webinars. It also goes through what we talked about today. You're also going to hear about a lot of families in here who didn't do it right, and some families who did do it right. The families who do it right get in here, and they get in with an attorney who's got experience, like our entire team has a ton of experience in this area. We've done well over 1,000 estate plans for people around Montana, Florida, Washington, Arizona, all the states we're licensed in. We've helped people, and there's nothing that brings us more joy than helping people get the right plan in place, because we love nothing more than knowing that your family's protected. Don't leave your assets up to risk. Please give us a call. We're happy to help you. We'll also send you our frequently asked questions, our FAQ. It's got 10 FAQs in it. That's a wonderful little tool. If you don't have one of those doubts in there, I'll be shocked, because many of us, a large majority of us, those FAQs hit home with us, and they're written that way on purpose. So Joel Silverman here with Silverman Law Office. Look forward to hearing from you. We look forward to helping serve you, and that's what we love to do. Thank you. Have a wonderful day.